capacity as an employee. He wasn't going to...
He made the request in his own capacity. He made them in his capacity as an agent or officer for Scripps? Or did he make, Mr. Williams make the request, not Mr. Williams?
I think the purpose of the request in that case was so that he would use them in an investigative report that he would then produce for his company, his place of employment. There's two other cases, Your Honor. Swift v. Campbell, the site on that one is 159 Southwest 3D. In that case, an attorney with the Federal Public Defender's Office in Nashville filed suit seeking production of TPRA denials. The Court of Appeals didn't address a standing issue in that case, but the case plainly moved forward. There was a similar case, Bote v. Ray. It's been since overruled by West, but as it regards to standing, similar situation there. An attorney with the Federal Public Defender's Office in Nashville filed suit following TPRA denials. And the logical conclusion of the argument the state is making is that reporters, investigators, attorneys, paralegals, really anyone else seeking records in any capacity would be denied from proceeding to challenge those denials. The opposing counsel also said that the requests in this case were invalid from the start, but as the court sees in the filings that we've made, the state responded to all of our requests in some capacity. We've obviously challenged the nature of some of those responses. And then Your Honor pointed out that the actual substance of the requests, the state said that they were made on behalf of FedSet. Those words don't appear in any of the requests. They all start with, I respectfully request. They are on company letterhead, and they are signed by Megan Kerrigan, but we would argue that she's plainly a citizen of the state of Tennessee. We don't dispute that the organization would not have standing to challenge this lawsuit, but Ms. Kerrigan plainly does. And Ms. Kerrigan is here. She does have a photo ID if the court would like to verify that.
Okay, but what about the language of 10.7.505A? Any citizen of Tennessee who shall request the right of personal inspection of any state, county, or municipal record. And then the inquiry there will be twofold. One, Ms. Kerrigan never made a request. If you take it that she made it as the agent for the corporation. And then the next inquiry would be, is the corporation a citizen?
The answer is plainly no, Your Honor. That the corporation would not be considered a citizen, I think, under the Tennessee Public Records Act. There's not a lot of case law on what defines a citizen.
Any citizen of Tennessee who shall request the right of personal inspection, if the corporation cannot be a citizen.
I don't think I understand the court's question. Ms. Kerrigan is a citizen of Tennessee.
Of the act, I'm just reading.
Yep.
Any citizen of Tennessee who shall request the right of personal inspection of any state, county, or municipal record as provided in 10.7.503 and whose request has been in whole or in part denied by the official and or designee of the official or through any act or regulation of any official or designee shall be entitled to petition for access to any such record and to obtain judicial review of the actions taken to deny the access. But in this case, Ms. Kerrigan ends her request stating the name of the corporation by her official investigator.
Your Honor, the only response I think I would have is Ms. Kerrigan is a citizen of Tennessee. She made the request under the TPRA.
She made the request, or the corporation made the request? If this was turned around, we were looking for liability. Would we be able to find Ms. Kerrigan liable for anything when she made a request in the name of the corporation by her as its agent?
For example, in Exhibit 1 to the petition, we have the request that you, Your Honor, obviously already highlighted. The email that was included that attached that TPRA request to Jen Brenner with the Tennessee said, I have also mailed a hard copy to your office. Please let me know if you have any questions. She's clearly making that request as a citizen of Tennessee in her capacity. The language in the petition that the state is hinging this entire argument on is intended to, the purpose of that was to illustrate to the court that, as an employee of a nonprofit organization, Ms. Kerrigan is not entitled to attorney's fees. We were not seeking attorney's fees.
But she said that because she said the corporation can't recover. It's not entitled to. But what do they have to do with it if she's the petition? How is it she can't recover? She can't recover attorney fees, an individual. What's in the petition is the corporation can't recover attorney fees. Therefore, the petitioner's not seeking it, like it's the petitioner is the corporation.
Your Honor, I don't know that I have an answer that's going to satisfy you, other than the case law that has focused on this issue has plainly said that an employee of an organization in the Scripps case can pursue the TIPA lawsuit.
In the employee's own right, which is what Mr. Williams did.
Mr. Williams is an employee of that news organization, was intending to use the records in a news story for that news organization.
Did his request say request by Mr. Williams as agent for Scripps, or was it just a request by Mr. Williams?
I'm not sure what the request in that case said. I know the request in this case did not say on behalf of. They state, as Your Honor pointed out, I am requesting. Ms. Kerrigan signs those, all of the requests.
Okay. Did either side look at the opinions of the Open Records Council?
I have not.
I have not on this particular issue, no.
You have not looked at them here?
I have not looked at them here for this particular issue, no.
Okay. I mean, they would be pertinent, would they not?
Assuming
Not governing, but pertinent.
Yes, assuming there is one on point, yes.
Well, I mean, did you consult the Open Records Council before you denied the request here?
So, Your Honor, the state seeks counsel on open records issues from the Attorney General's office. That is correct.
Nobody consults with the Open Records Council?
Not from the state, Your Honor. From the state, they would consult the Attorney General's office.
Okay.
But the cities, the counties, the other governmental organs, they would consult the Open Records.
Okay.
So,
All right. Okay, we'll take a recess before we come back on the motion, unless you want to have something else.
no, Your Honor.
Okay, all right, we'll come back. Stand in recess.
just completely removes it, just takes out the the statute's unconstitutional. It doesn't give any process. It doesn't give any process. Just want to flesh it out. Couldn't be combined with the UAPA. But if it takes out utility.
Okay.
Your Honor, briefly, during the recess, we found an opinion from the Open Records Council. It's a 2012 opinion, but it does, okay, thank you.
Thank you. Okay, let this be the opinion of the court on the defendant or respondent's motion to dismiss. And the court reporter's requested to transcribe the court's opinion and then to submit a copy of the transcript of the opinion for correction, revision, or change. Court reserves the right to make corrections, revisions, and changes upon the transcript of its opinion on the motion by interlineation. Okay, on October 27, 2025, the petitioner Megan Kerrigan filed a petition for hearing on public records request, denials, and access to public records. This court did not learn of the filing of the petition in the clerk and master's office until November 3, 2025, and immediately on that day issued a show cause order for a hearing on November 12, 2025. And by agreed order entered November 13, 2025, per agreement of the parties previously made, the court continued the hearing to November 19, 2025 today. And the purpose, I believe, of the agreed order between the parties was to resolve a conflict that the state's council had on November 12. By fax filing made last night at 5:08 p.m. Central Time, 6:08 p.m. Eastern Time, after the clerk and master's office had closed, the defendant filed a motion to dismiss for lack of subject matter jurisdiction and failure to state a claim. That motion was based upon the ground that the public records suit has been brought in the name of the individual Megan Kerrigan, but that the public records requests were made by the corporation Federal Defender Services of Eastern Tennessee, Inc. Each request was made in writing and begins with Ms. Kerrigan stating, "I request." Let me ask this, counsel, is there anything in here to indicate that the requests in this case, which included requests for copies, had to be made in writing? Okay, because often under the Public Records Act, the person just goes up to the counter and asks to see the records. Do you know?
Your Honor, I'm not aware of anything that would suggest it has to be.
You can do that, you can require that if copies are sought, but, okay, you're not.
Yes, I'm not
That
sure.
wasn't the case here,
Yeah.
though, right? She did not have to request these records in writing, she could have just appeared and requested them orally?
I don't know the answer to that, Your Honor, I apologize.
Okay, all right, okay. Okay, the requests are made stating, "I request," in the beginning, but at the end, each request is signed, "Federal Defender Services of Eastern Tennessee, Inc. by Megan C. Kerrigan, investigator." And under general law, and general case law and statutory law, a corporation in Tennessee is a person, but is not a citizen. All right, in none of the department's responses, however, does it state anything about the requester's citizenship or require any ID. The requirement that a person requesting public records must be a citizen residing within Tennessee grows out of Tennessee Code Annotated Section 10.7503A, capital A, Roman numeral 6, which states,
A governmental entity may require a person making a request to view or make a copy of a public record to present a government-issued photo identification if the person possesses photo identification. That includes the person's address. If a person does not possess photo identification, then the governmental entity may require other forms of identification evidencing the person's residency in this state. Okay. Thank you. In fact, the Tennessee Office of Open Records Counsel issued an opinion on November 9, 2012, that a corporation does not have the ability to provide a government-issued photo identification and therefore is not a citizen within the Public Records Act, but states that it is also the opinion of the Office of the Tennessee Open Records Counsel that when an individual who is making a request on behalf of the corporation is able to produce a government-issued photo ID that includes a Tennessee address, any record responsive to the request, and is not confidential, is required to be made accessible to the person making the request. And there's nothing here to indicate that such is not the situation here. The court is looking at the Open Records Council's opinion, or opinions, simply as secondary authority to be considered. The Tennessee Open Records Council also issued a consistent opinion on September 23, 2015. The person who actually made the request here was Megan Kerrigan, although she indicates by her signature that she is making the request as an investigator for the Federal Defender Services of Eastern Tennessee, Inc. The Open Records Act at Tennessee Code Annotated Section 10.7.505D says that TCA Section 10-7-505, which authorizes suits, is to be broadly construed so as to give the fullest possible public access to public records. Okay, although Ms. Kerrigan was getting the records for the corporation, there is nothing to indicate here that she was not a citizen getting the records. The purpose of a request for public records is generally not relevant unless there's some type of allegation of intended disruption or improper purpose in that regard. Otherwise, it doesn't matter why the person's getting them, if they're getting them for one person or another, as long as they're a citizen getting them and seeking them. I believe that is what the Open Records Council is getting at in the Open Records Council's opinions, which again the court says is just secondary authority here. So the motion here will respectfully be denied, and we'll move on to the hearing on the merits of the petition. Let me ask this as we move on to this, and this will be on the actual petition of Megan Kerrigan. We're hearing on the public records request denials and access to public records. Do the parties agree that Megan Kerrigan, and this is without waiver of anything in your motion to dismiss, and the parties agree that Megan Kerrigan is a citizen resident of Knox County and that the request for public records and the denials are as set forth in the exhibits 1 through 12 that are attached to her petition?
Yes, Your Honor, we could agree to that.
Other side? Yes,
Yes, Your Honor.
Okay. All right. Can the parties agree that the department, and I believe you do in your motion, that the department has the burden of proof to
show by preponderance of the evidence the justification for the non-disclosure of the records.
Yes, Your Honor.
Yes, Your
Okay, all right. Okay, with that being said, we would generally go over to the department, but let's hear first from the petitioner. It's on your petition.
Thank you, Your Honor. The state's response, or the state's response to the public, to the petition that was filed as part of the motion to dismiss, broadly interprets the Tennessee Public Records Act to exclude any records related to execution secrecy. The specific language used by, in the denial, is that Tennessee Code annotated, this is from the response, 10.7.504 protects information that could be used to research the identities of persons and entities involved in executions. That is not what the plain language of the statute holds. The plain language of the statute says, notwithstanding any other law to the contrary, those parts of the record identifying an individual or entity as a person or entity who has been or may be in the future directly involved in the process of executing a sentence of death shall be treated as confidential, shall not be open to public inspection. Part 2 of the execution secrecy statute says, the information made confidential by the previous subsection shall be redacted wherever possible, and nothing in this subsection shall be used to limit or deny access to otherwise public information because a file, document, or data file contains confidential information. I want to talk briefly about the Bote v. Ray case. That's a case that's been abrogated, since been abrogated by West v. Schofield. But the issue in Bote v. Ray, the Court of Appeals held that the restriction in the statute that said those directly involved in execution is significant. And I'm quoting from the opinion here, Your Honor. Do you need that cite?
No.
Okay. Direct involvement denotes participatory actions in the occurrence, not tangential actions. Essentially, the Court of Appeals granted the public records request in that case because it held that the execution secrecy statute only limited the records to those directly involved. The legislature did not disagreed with that court's opinion and then passed the revised execution secrecy statute. And the opinion in West v. Schofield outlines the disagreement there. And this I'm reading again from the opinion in West v. Schofield. Senator Norris's comments, which we have included in our petition and are quoted in full in the West case, clearly indicate that the legislature disagreed with the Court of Appeals construction and that the legislature intended through its amendment to the statute to protect the identities of all persons and entities participating in the execution of a convicted murderer. That was the legislative intent. The legislature disagreed with the opinion in Bote, sought to amend the execution secrecy statute, and still only limited the exemptions to the identities of people involved. I wanted to also briefly touch on the state in their, or the respondents in their Exhibit 1 have filed a protective order that was entered in a separate case in a different jurisdiction in Nashville. However, what the state omitted from that filing was the memorandum and order filed along with that protective order. And if the court is amenable, I'd like to file that now as an exhibit.
Any objections?
Can we look at it
Yep,
first?
okay.
I'm sorry, what's that?
Can we look at it?
Yes, please. I won't look at it till the department responds.
objection to this being entered, Your Honor.
Your Honor, this was the memorandum and order entered by Chancellor Perkins contemporaneous with the protective order that the respondents have included in their motion. And I asked to include it in the record here because I think it points out some of the misrepresentations that respondents have made in their response. Starting on page 2, I just wanted to highlight the last paragraph right before the discussion section. Defendant's motion for a protective order, although informed by records requests made under the TPRA and possibly actual or anticipated written discovery requests, is not actually bound to particular pending discovery requests or pending TPRA requests, but rather is an effort to proactively seek a framework for addressing these disputes. And I point that out to say that that case is substantially different than this one. That is a case challenging the constitutionality of the revised lethal injection protocol, and the protective order entered in that case was to facilitate the discovery process in that case. On page 4 of this memorandum of opinion, the Chancellor actually disagrees with the arguments made by the state in that case, and they're the same arguments that the respondent has advanced here. Starting at the top, on its face, the statute does not appear to make these identities confidential in an absolute sense, but rather contemplates that restrictions such as redaction be put in place to keep these identities confidential and to make associated material disclosable. The court continues on the next 3 paragraphs to say that the use of redactions and pseudonyms can be used, but ultimately orders that these documents should be produced. I also wanted to note for the court on the bottom of page 4 there, footnote 2, the respondents in their response to the petition allude to a statement that the court in Nashville did not need to conduct in-camera review. The only thing mentioning in-camera review in either document is this footnote where the Chancellor says that there may become a time where in-camera review is necessary. And then finally, just on page 5, the court also holds that the identities of all persons and entities involved in the procurement or provision of chemicals, equipment, supplies, or other use in carrying out the sentence of death shall be treated as confidential, but again, talks about the use of redactions and pseudonyms in turning those documents over. So, Your Honor, we believe that the requests that we've made do not seek the identities. The respondent's interpretation of the statute to, it's attenuated and tenuous based on the use of the information can be used to reveal the identities. That is not what the statute says. That does not establish their burden.
Okay.
Thank you.
All right, thank you. Department?
Yes, Your Honor. So first, to begin with the issue of the protective order, pick up where opposing counsel left off. The memorandum order that was just entered into evidence was reconsidered, is my understanding, and that the protective order that ultimately issued came after that order. The court thought about it again and changed its mind. And the issue of the protective order is we're really just relying on it as secondary authority. It supports the way we believe that 10.7.504.8 should be interpreted. A little bit of context is necessary to understand our interpretation of the statute here, Your Honor. It's extremely important for the state to protect the identity of the entities who are supplying the lethal injection chemicals. The chemical the state uses now is called pentobarbital, and it's extremely difficult to get. And anti-death penalty activists have a strategy, and that strategy is to identify the supplier, threaten the supplier with negative publicity, and convince the supplier to stop selling the drug to the state. And 10.7.504H is the General Assembly's response to this dynamic. And the statute is intended to protect entities supplying the drug to the state. And the petitioner's reading of the statute is so narrow that there's no way to accomplish the purpose of the statute under their interpretation. simply redacting the name of the entity from the information is not nearly enough to protect this extremely confidential information. In today's day and age, Your Honor, everybody has internet access. Everybody can use ChatGPT, and with just a few bits and pieces of information, it's very simple to track down these suppliers. And so just redacting the name is not going to do it.
Couldn't you redact the other information?
Well, Your Honor, we believe that that we can't provide any of this information. Though, in terms of the responses that where we could redact the information, we did and provided documents. Where we couldn't do that, we withheld the documents entirely under 10.7504H. And we think that that's a reasonable interpretation of the statute. It's not contrary to the plain language at all. The statute doesn't just say directly identifying information. It says identifying information. In order to actually effectuate the purpose of the statute, it's reasonable to interpret it as protecting information that could be used to research the identity of these suppliers. And that's why we deny these requests. To protect the identity of the supplier, to ensure that they're not doxxed and harassed by anti-death penalty activists, and to ensure that the state can continue to receive these chemicals to execute its lawful duty. And additionally, there's a few other statutes we relied on. We rejected a request for health information. That request was for the vital signs of Oscar Smith. There we asserted 10.7504A1. We believe that the more appropriate reason to deny that statute would really be the regulation, the department's regulation that protects inmate health information. That regulation is 0420-01-020.06. 1A.
That's not in the Public Records Act.
It's not in the Public Records Act, Your Honor, but it is an agency rule and regulation. And
can that override the public's right to access to records?
So, Your Honor, in Swift versus Campbell, the court lists what qualifies as state law. So you can deny a public record request if it's confidential under state law, and then in that case, the court lists what is state law. And regulations are state law. So if the Public Records Act 10.7504A1 doesn't exactly apply, and we're not saying it necessarily doesn't, we're just saying we think the easier, more accurate citation would be this regulation.
Here?
I have it quoted. I don't have a full copy of it.
Okay. Is that the inmate's health information?
Yes, Your Honor. The regulation makes confidential, quote, medical or mental health records.
Okay. And is that created by the health department?
That is a regulation of the Department of Correction.
Okay. And it relates to their mental or physical health?
Insofar as the request is asking for vital signs from Oscar Smith, we believe that is health information.
Health information?
Yes, Your Honor.
Okay.
That would qualify.
Definition of health information?
I don't have a definition of health information. The statute the regulation, protects medical records, and so we believe that.
For medical treatment?
See,
This is for treatment, is it?
I agree, Your Honor. I wouldn't argue that an execution is medical treatment. But I would argue that the records detailing the inmate's vital signs are a medical record. And the regulation doesn't have that qualification.
It's not for medical purposes, though, is it?
The regulation doesn't have that qualification that it must be for medical treatment. The statute uses the phrase medical treatment. The regulation does not.
Medical purpose.
It uses medical.
What's the medical part of it?
The medical part is that it's tracking the health information of.
Physiological information. But
yes.
what's the medical part as we normally consider medical?
The fact that they're tracking this information, they're tracking this visit.
Physiological information.
Yes, I believe that that would be enough to qualify it as a medical record.
As a medical.
Yes.
There is no medical treatment here, correct?
Correct.
And there's no concern with the health of the inmate, correct?
Correct.
There's no concern with the medical condition of the inmate, is there?
Insofar as they want to ensure that the procedure is effective, they're tracking to make sure that the inmate has died. I wouldn't call that medical treatment, but I think it's fair to call that a medical record. And so as far as they're tracking the life of this individual, not for the purpose of treatment, but for the purpose of understanding whether he's alive or dead.
And who renders the record?
Your Honor, I believe that, I don't think I'm free to speak to that
I don't mean
information.
the individual involved, but is it a department, a profession, what?
It's the Department of Corrections, yes, is
The
doing
Department of
this.
Corrections, so. Okay.
Your Honor, but we also asserted in our response another basis for denying the request for the medical information, and that is 107-504H again, because the statute doesn't, the statute doesn't just protect the supplier of chemicals. It also protects the supplier of all the equipment that is used in the execution. And so all of this medical equipment that was used to produce the record, we believe that that cannot be disclosed without disclosing the identity of the suppliers of that medical equipment as well.
You can't disclose the information from the strips
That is
without disclosing the providers of the equipment?
that is our position.
What would be the problem there?
Your Honor, we'd have to look at the records to really get into that, but that is our position. Yes.
Okay, but what's the logic?
The logic is to protect the.
No, I understand your purpose. What is the logic for saying we can't give you the information from the strips without giving you the information as to who provided the strips?
That would be, I think you would have to look at the way the record is configured, and is it possible?
You can't redact it or otherwise provide it?
It's our position, yes, Your Honor, that the nature of the record, that redaction would not be sufficient to protect the identity of the suppliers of this medical equipment.
No, okay. You can't give the vital statistics without disclosing the provider of the equipment.
Your Honor, I believe that if you're asking if we can simply take all these statistics out of their current form in the medical record and just give the statistics, that would require the department to create a new record.
You can't just block out the part that has the confidential parts. You can't block those parts out.
That's
There's
correct,
nothing
Your
you
Honor.
can do there. You cannot, so here, in this case, the redaction provision of the Public Records Act has no application. That's what you're saying, right?
Your Honor, we redacted where possible. We redacted where possible, where the information that we withheld could be used to research the identity of these suppliers. And so, yes, we believe that to adequately protect the entities that are providing either equipment or the chemicals to the department, it is necessary to be extremely cautious about what is released, because just bits and pieces of information can result in people identifying the supplier.
How would the information, the blood pressure was at the time?
We don't have.
How do you, or, well, I'm sorry, go ahead.
My understanding is that we don't. All we have is the medical records as they are currently formulated. So we can't simply provide them the vital statistics without creating a new record. We only have the medical record as it exists, and we don't.
You can't redact part of it and just show the statistical part.
Yeah. Yes, Your
It's
Honor.
hard to visualize.
Certainly. I understand where you're coming from, Your Honor. I believe that would just be in the nature of the record. You'd have to look at the record to see if that's possible. It's my client's position that when they've reviewed the record, they don't believe that that's possible.
Okay.
So there's also allegations in the petition where for some of the responses, the department indicated that it simply did not have possession of those records. And I just wanted to point out that we provided an affidavit, it's Exhibit 2, from Patrick Newport, the respondent, who is charged with answering these public records requests. And he did his due diligence, Your Honor. He searched for these records. He talked to the people he was supposed to talk to, and he wasn't able to come up with responsive records to those requests. So there was nothing willful about the assertion of not having any records in that situation. And finally, I'll turn to...
In the responses to the responses to the request, weren't all of them denied based on confidentiality?
No, Your Honor, not all of them were denied. Where it was possible to employ redactions without disclosing the identity of the supplier, we did that. We provided records where we could. So some records were provided, some redacted records were provided. The requests were not outright denied entirely. So there's really, I think there...
Is there any place there where you said they don't exist?
Yes, that's what I was just
in the
suggesting.
denials, in the original denials?
Yes, there were certain requests.
You said there are none.
Yes,
Okay.
to certain requests there were no records. The department just simply didn't have records responsive to that request. And I just wanted to say that we provided an affidavit in support of that contention.
The ones where in the denials where you say that they don't exist, Mr. Newport has given his affidavit that those records do not exist.
Yes.
Were there any that you said were denied because they're confidential, and then in Mr. Newport's affidavit he says they don't exist?
I don't believe so, Your Honor.
Okay.
Yeah, his affidavit is limited to the requests where there was no records at all. The issue of whether 10.7.504H applies is a legal issue. So we didn't provide evidence on whether that statute applies or not. That's a legal argument. We provided an affidavit on the issue of whether the records exist at all, because that's a factual issue.
Okay. Well, as to the request, most of the denials appear to be under 10.7.504H1, correct?
Yes, Your Honor.
And that those parts of a record identifying an individual or entity as a person or entity who or that has been or may be in the future be directly involved in the process of executing a sentence of death shall be treated as confidential and shall not be open to public inspection. That's where it's under that statutory language that you deny most of the records as being confidential, correct?
Correct, Your Honor.
Okay. And what about the language about identifying an individual or entity as a person or entity where that has been or may be directly involved? What is your argument there?
So as far as the people or entities directly involved, the statute is pretty clear on that point. The statute says, I think it uses, if you provide or procure chemicals, equipment, an entity that does that is directly involved in the execution. If you provide the chemical to the department, you are directly involved. The issue facing this court, as I understand it, is whether the statute protects information that directly if it only protects information that directly identifies the entity, or if it also protects information that indirectly would identify the entity. And it's our position that it's not in the statute at all, Your Honor. It just says identifying information. So I think the question before this court is whether it's directly identifying information only, or
Which way
also.
would the court construe the exceptions? Broadly in favor of the exception, or narrowly against the exception? How do you do, which approach do you take under the Open Records Act?
Well, the Open Records Act, generally there's a presumption in favor of openness. I think the case law is clear on that point. In this situation, I think it's not a 50-50 interpretation.
Is there any part of the statute that singles this confidentiality provision out and enhances it?
The fact that the statute directly mentions suppliers of chemicals, we think is strong evidence that the General Assembly is really trying to protect the identity of suppliers. And the only way to do this is to protect information that could be used to research the identities, information that indirectly could lead to the discovery of the supplier. If all we're able to do is redact the name, the day we release these, everyone will know who the supplier is. Because that's how they can take the information, they can use it, they can research it, they can have access to the internet. There's very few of these suppliers. It's not hard to figure out who's providing these chemicals as soon as this information that we have is released. And so to affect...
Very few of these suppliers, and the people you're protecting them from already know who this small group is. And there's a very small group. What would be the news?
Well, Your Honor, they don't know which one. I mean, right now it's still confidential, and so we don't want to tell them who it is exactly, so that they can go start a doxing campaign against Tennessee's supplier of this chemical.
A person or entity under the protection, there is defined as, I believe, an employee of the state who has training related to direct involvement in the process of executing the sentence of death, or a contractor or an employee of the contractor, a volunteer who has direct involvement in the process of executing a sentence of death, or a person or entity involved in the procurement or provision of chemicals, equipment, supplies, and other items for use in carrying out a sentence of death. And that's the part you're concentrating on now, correct?
Correct, Your Honor.
But it says a person or entity involved in the procurement. And you're saying that means no information about anything.
That's not exactly what we're saying.
Well, anything concerning chemicals, equipment, supplies, or other items, right?
Your Honor, our position is that information that could be used to research the identity of the supplier is protected.
And if you just add the chemical, the type of chemical, they could do that, right?
Well, the type of chemical is public knowledge. It's pentobarbital.
Your inventory of pentobarbital, that's protected.
Yes, Your Honor.
Now, if you have so many units of it, how does that lead to discovering a person or entity involved?
Your Honor, I would have to, I'll have to defer on that question. I don't want to say exactly how, and I would need to confer with my client to explain exactly.
The quantity of units would lead to the identification of the person or entity. How can that be?
Your Honor, we believe that with each of these requests, there is a good argument that you can track down.
I never get the specifics of the arguments. I just get that that's protected. I mean, the arguments are protected.
Sure, Your Honor. There's many.
No way to do this.
There's many of these requests. We're here. We're here. What, 10, 15 days after the petition? So we're doing our best here. We are happy to provide a supplemental brief that would go through each of these requests and explain to the court exactly how this information could be used.
But that's what we're supposed to do today, right?
Your Honor, yes, and if you look at our response, we do go through a few examples. So
Well,
we
that's
don't
not
go through
a
each
few
request.
examples. Okay. I mean, that's kind of hard for me to then have to go through each one when you give me a few examples with some arguments. But I don't get any really specific arguments. I get sort of general arguments, and that's because you say you can't argue it without disclosing confidential information. Okay, let's see. The next subsection of the Act, 107504H2, says that information made confidential by this subsection H, and that's the very specific part of the statute we're under, shall be redacted whenever possible, and nothing in this subsection H shall be used to limit or deny access to otherwise public information because a file, document, or data file contains confidential information. So what do I do with that?
Your Honor, we are aware of that provision, and we tried our best to comply with it. We redacted where possible and provided those records to the petitioner. So it's simply a matter of what does 107504H make confidential. We believe that it makes confidential any information that could be used to research the identity of the
So
supplier.
what would my findings be based on here? That the department says it can't really argue this without disclosing confidential information, and they've done their best. That would be my findings. Or give me something else that I could add to those findings.
Well, Your Honor, I mean, your findings would be that we have proven by a preponderance of the evidence.
What evidence?
Well, the evidence would be the interpretation of the statute that we're
There's
providing
no
for you.
evidence. I have no evidence of anything from you. I'm not
Well,
faulting you in that
so-
regard, but I don't have any evidence.
That's correct, Your Honor. Besides the affidavit and the protective order, the evidence would be the statute gives you the authority to order an in-camera review of the records. So that would be the evidence.
That's an alternative, but if I don't want to go there, I don't have anything yet, right?
That is correct. If you don't want to go there, Your Honor, you would simply be making your findings. You would say that we've put forth we've met our burden by a preponderance of the
What'd you put
evidence.
forth?
We've put forth legal arguments that
Okay,
explain.
but no evidence. I don't have any preponderance of the evidence. I don't mean to be argumentative with you, but how can I find out by the preponderance of the evidence when I don't have any evidence?
Well, Your Honor, that's why the statute contemplates the ordering of the in-camera review. I mean, the evidence
It was in the alternative.
I don't know if it's in the I don't remember. I'd have to look exactly at the statute. I think it just gives you the authority to do that. I mean, this is just the nature of how public record cases work. They file the request, we deny the request, then we explain why we denied the request. And that's what we're attempting to do to you today. We denied the request under 107504H. For you to determine whether whether we're correct, almost requires looking at the records. And I'm not necessarily asking you to order in-camera review, but I am saying that if Your Honor wants evidence, the evidence is the records that were withheld. That is the evidence. And the legal argument that we're putting forth today is based on those records.
Go ahead, sorry.
I believe that that's all from the state at this
Well,
point.
Does the department take the position that all the information not produced is confidential, and the confidential information, all of it, none of it, can be redacted? Is that right? I mean, just...
Yes,
Okay.
that is right.
All right.
What we have provided already is what we believe we can provide.
All right, and putting aside redaction, you take the position that all of the information not produced thus far is all confidential?
Yes, Your Honor.
Under the statute. Okay. And the records you have produced are what now? Which ones have you produced?
So that would, we produced a variety of different records in response to a number of different requests where we redacted where possible.
Which ones?
I'd have to look at the petition specifically to name the exact request that we respond to. I'm sure
How many of
petition.
them are there that you have complied with?
So there's 4 separate requests, each with about 40. I would think they each have about 10 different requests inside of those. So there's about 40 different ones.
And of that, of the 4 general requests with 40 subparts, how many subparts have you complied with?
I don't have a specific number.
How many general requests are there?
I would estimate about 40.
40 general.
There's about 10. Would you say about
So
10 in each?
complied with 4 of the 40 general requests. How many subparts from the others? Does each one have about 10 subparts?
Yeah, Your Honor, I'll have to just look at the actual request. That's the only way I'll be able to answer your question.
About 8%, 10% of the requests?
So, I mean, that sounds about right. I'd have to look. We provided the records where possible.
What do I look to determine what has been provided with respect to the request? What's the easiest way for me to access that?
We could provide you
It's
a
in
supplemental.
In the suit, how many of those have been provided?
I don't know the exact number off the top of my head.
I mean, after the suit was filed, then some of them were complied with?
Not after, no, not after the suit.
So none of the requests in these exhibits, 1 through 12, have been complied with, right? Or not?
So, Your Honor, there's 4 requests.
Okay.
I'd have to look at each individual request to see which ones we provided responsive records to and which ones we did not.
Okay, well, help me here, though. What do I look to so I can determine whether or not I'm dealing with something that's...
It's my understanding
or not?
that they're not challenging the records we provided. They're only challenging the records we didn't provide.
So all of the ones that they list have not been provided, right?
That's correct, yes. The ones that we denied under 107504H, the ones where we said we didn't have any records, and then the ones where we said that they were health information under 107504A1. Those are the ones we did not provide.
Okay. I would take all of the items they requested. Let's see. And then I would have to take Mr. Newport's affidavit and see if it matches up with something in these 12 lists or 6 lists and check those off. How do I, help me here as to how I can formalize this so I can analyze what's been produced and what hasn't.
That's correct, Your Honor. So the way I understand it would work is that we would identify the records that we believe are responsive to each request, and then we would provide you those records, and you would...
I'm not talking about today. Is there any way I can determine this today?
I mean, Your Honor, if you... Yes, you could determine this today.
How do I do it here without going through with you, item by item, each item?
So the way that I would do that then, if you don't look at the records, is to look at...
No, I mean, just doing it today with what I have.
Sure.
What can I do?
You would look at the language of the requests, and you would say, does that request reasonably... Could that request reasonably lead to information that could be used to research to identify the...
And even though none of that is in the statute, correct?
Where does that
language come from?
This...
Like discovery, it sounds like
Sure.
the old discovery rules.
Where does that line?
So the statute doesn't use that language specifically. The statute just says that the identity of the supplier is protected. And so the question is, does the statute only protect information that directly identifies the supplier, like the supplier the latter, because that's the only way to actually protect the identity. Simply redacting the name, as petitioner thinks we should do, is just redact the name of the supplier and then give them everything. That's not going to do it. That's just simple.
I have all these lists. I have really few complying responses, correct? I mean, whether
Sure.
it may be justified
Sure.
not doing so, but in actuality, I have very few complying responses. So, but what you would propose I do is I go through all of their responses, all their requests, and then analyze whether or not they should be required, whether you should be required to respond to it, as for instance, it might contain information that can lead to the identity of the supplier. But you're the one with the burden of showing that the failure to respond or produce the records is justified, not me. But if I do it your way, what would I be doing? Representing your side and saying, oh, can I come up with this or that, or representing their side? How would I do this? I have nothing.
Yes, I understand the position you're in, Your Honor, and I just think this is how public record cases work, where the evidence is twofold. The evidence is the request. What is the request asking for? Sometimes it's very obvious based on that. If, for example, they had a request that said, produce the names of the supplier. If they specifically asked for the name of the supplier, you could easily say the department was justified in yes.
Yeah.
So you can look at the request. That's one way to do it. If there's not enough there, I believe there is enough there. But if there's not enough there, the only other way would be to look at the actual records.
Okay, on these vital sign monitoring strips, such as the EKGs, the pulse oximeters, the CO2 blood pressure strips from the inmates at the time of execution, I have your position stated, so let me ask you again, does the department take the position that those records constitute medical records of patients in state, county, and municipal hospitals and facilities, or medical records of persons receiving medical treatment in whole or at the expense of the state?
Your Honor, so that's 107504A1.
Is that your position?
Our position is now based on the regulation
Okay,
primarily.
you're abandoning that position?
Yes.
Okay,
We are traveling under the regulation.
okay, you abandon that position, and then do you also abandon the position that the items constitute health insurance collected, created, or prepared by the Department of Health for individuals containing individually identifiable health information, meaning information related to the physical or mental health of an individual?
Yes, Your Honor. I don't believe we ever asserted that particular portion
Never asserted.
of the statute.
Okay.
Our position with respect to the vital signs is that they are confidential under 042001.020.06 Section 1A, which is a regulation of the Department of Corrections, which makes inmate medical records confidential. There's no treatment language in there. It just says medical record, and we
Is
think
there any, under that theory, is there any reason the Department of Corrections couldn't just say, we regulate that all of our records are confidential?
well, certainly all inmate medical records are
No,
confidential.
all records. We will enact a regulation, all records are confidential.
That's an interesting question, Your Honor. I don't necessarily have an exact answer in terms of what statutory authority does an agency have to make records confidential.
Well,
I don't
under
know.
this theory, they can just make them all confidential, and then nobody can ever see anything. They can override the Public Records Act.
Your Honor, I believe that State versus Swift,
Okay,
it doesn't.
under State versus Swift, the agency could override all the other provisions of the Public Records Act. And could it? Or could it not?
Your Honor, I don't know. I don't know about the statutory authority. I mean, they can pass regulations that they have authority to pass.
Okay.
So if they have a statute, an enabling statute that allows them to make all their records confidential, they could do that. I mean, I can give you one example with the Department of Safety has a new immigration division, and the statute in there is going to essentially allow that department to make all those records confidential. So certainly the General Assembly could empower the department to do such a thing if it wanted to, but it hasn't. I mean, and the agency has authority. I don't see why they don't have authority to make inmate medical records confidential. I mean, I don't think the personal health information of inmates is something the public needs access to.
Inmate records this is inmates who are being executed, their records. Which
Yes, they're still
you
inmates.
would have it grouped with those getting treated for something, like the flu or something.
The statute that was originally asserted has that treatment language. That is correct. But the regulation does not have treatment language in it. It simply says medical record.
Okay. All right. Okay. Anything else?
Not from the state, Your Honor, unless there are any further questions.
No.
Thank
Thank you.
you.
Okay, back to the petitioner.
Your Honor, I think we would just say that the General Assembly has stated specifically the intent under the Public Records Act. They have specifically identified exemptions, including in the execution secrecy provision under 107-504H. That provision, as our Tennessee Supreme Court found in West v. Schofield, specifically exempts identities of persons and entities. Regarding the medical record provision, we would obviously take the position that the state relied on 107-504A1 to deny those records. Our position, as stated in the petition, is that those were not records created for medical treatment. And I did want to also highlight that there's a case, Hickman v. Tennessee Board of Probation and Parole, where the Court of Appeals basically said that even if records contain confidential information, the Tennessee Public Records Act requires their production, including if it, in that case, the state had to create a new system to be able to distill the records. That's all, Your Honor.
Okay, let me ask this. You
Yes, sir.
also requested photos, videos, and audio relating to the execution of the inmate. I believe you have it phrased, so it's not involved in will. How could you ever have that? How could that be redacted without showing the entities of the persons involved in carrying out the execution?
I believe that is one of the responses, without having that specific request right in front of me, that the department has said they don't have responsive records for. My understanding is that the video contemplated in the protocol is a live stream that's pumped into the witness room. And so under that, if that is the case, then we would not certainly be entitled to that information.
Well, I mean, well, the request is photos, videos, or audio relating to the execution. There's no way to redact that, is there?
Not that I would be aware of, Your Honor.
Are you still making that request?
I would have to. Do you have that specific request in front of you, Your Honor?
No.
I believe that is at request 10 in Exhibit 4.
Yes.
As we've mentioned in our petition, all of our TIPA requests were crafted on specific provisions of the protocol. And so that specific request cited to, I just lost it, there it is. There were potential issues setting the IVs for both of the inmates that have been executed. We were seeking any video, photographic evidence of the misplacement of the IVs, and then any events that transpired in the execution chamber. The execution of Oscar Smith was delayed by about 20 minutes, and then there's obviously been media reports about Byron Black's execution. So to the extent there was any relevant information captured in video or photo, that was the nature of that request. But I would agree with Your Honor that under the identities provision of the secrecy statute, we would not be entitled to that.
Okay, so those requests, do you withdraw them?
We would withdraw request 10 on Exhibit 4, yes, Your Honor.
Okay, is there another similar request in here? Well, the others went well. We have another 10.
Request 10 on
Mr.
Exhibit
Black.
10, yes, sir.
Okay. Do we have another request like that?
I don't see any that specific request, photographic and videographic evidence, Your Honor.
So,
And Your Honor, my co-counsel just mentioned that the photographic evidence of the inmates themselves would not be protected under the secrecy
no,
statute.
I'm asking how would it be redacted? I mean, it would just, you're saying that this just includes the inmate, it wouldn't include anyone else?
That request, Your Honor, I think as written is broad enough to encompass everything, and that's, I think we would have to withdraw that request, Your Honor.
Okay, so are those requests withdrawn?
Yes, sir.
Okay. Okay, do you know of any way the court could decide what I have before me without the records?
So we included in our petition the letters of responses from the TDOC. We did not include the records that we have gotten. So there are, and you would see in our exhibits, there are a few requests that were responded. They're mostly practice logs that have basically the names of the participants redacted. And we are not challenging those requests. We would be happy to provide those to the court so that you can see what we do have. But beyond the state's arguments today, Your Honor, I don't know what, I don't think the state has met their burden of establishing this preponderance of the evidence.
But these provisions are for the protection of others, correct?
Correct, Your Honor. So
They're not here.
So, for example, request number 1A asks for the quantity and inventory of lethal injection chemicals currently in the possession of the Tennessee Department of Correction. I don't believe the respondent has met their burden to show why that denial of that specific request is beyond the preponderance of the evidence, how that would lead to, and first of all, I think the plain language of the statute would prohibit the identities and of the persons or the entities. The state is making the attenuated argument that that information itself could lead to the discovery of information And that is not what the plain language of the statute says. That's not was not the intent of the legislature, and I don't believe that they've met their burden to show why the denial.
Well, have they met their burden on that?
I'm not sure that they've met any burden today, Your Honor.
Okay. So your position would be, they didn't meet their burden today, therefore the court should own that technicality. And I realize that not meeting your burden of proof
That's not a technicality, Your Honor.
is a nitpicky technicality, but that I should order all these records produced, even though those entitled to confidentiality would lose that confidentiality without anyone ever having seen anything upon which the state bases its arguments.
Your Honor, I think the premise of that question is accepting the state's position that any of this information could lead to the discovery of identities.
This is not right, so you're going to have to disclose it all.
That's the specific. We've made some specific requests here. Quantity and inventory of chemicals, the results of testing, use by dates, expiration dates, how the chemicals are stored. That information is not under the plain language of the statute, and I don't know how attenuated the respondent believes any of us are, but I don't know how any of that information could lead to the disclosure of an identity.
Regarding the transportation, so that's going to have the transporters in there, isn't it?
I don't know what the record would have potentially, but again, under H2, I'm sorry. Yeah, I'm sorry. Under H2, that is information that could be redacted and produced, consistent with the Public Records Act. And again, Your Honor, I'd point to the exhibit filed today from the Chancery Court in Davidson County, where the chancellor there held that redactions, the use of pseudonyms could be used, and if it got to the point where there was in-camera inspection, that would be another sort of issue to address. But we believe that these records, number one, under a plain reading of the statute, can be provided, should be provided. But even if even if there's identifying information that we're not anticipating or knowing that there might be in some of these records, I think H2 then would hold, and that information could be redacted and produced.
The storage of the chemicals, I don't know where the storage is, so.
I don't know either,
If
Your
they
Honor.
give you any information as to where it's stored, and it's not within the department or within a public facility, then.
I think the issues with the storage is the chemicals have to be held at certain temperatures, and so information about the storage could show whether chemicals are falling out of solution, whether chemicals are expired, that type of thing. That again is not something that I believe would lead to the identifying of any persons or entities consistent with the statute.
Okay, now how do I access where they have redacted records?
The records that have been provided,
Yes, and redacted.
we have those records. We'd be happy to provide those to the court.
Which ones of the, how many do I have here?
So the request that I have as being provided,
How many subparts have you requested?
well, for example, on September 9th, 2025, the state denied every single request. There was request number 1, subparts A through E, request number 2, subparts A through E. So that's 10 requests total in that request. In
Do
September,
you know approximately the total, how many subparts you've requested? Subparts of the request you have? Is it 100?
no, Your Honor.
50?
I would believe it's less than 50. I'd be happy to provide that number to the court, though. And when we say subparts, you know, for example, on the September 9th, 2025, this is the response. The number one, it says, information regarding the inventory of lethal injection chemicals and equipment for use in the execution of Oscar Smith, including, and then the subparts list the various levels of what we believe might be in that inventory. These are not subparts where there are, you know, substantially different requests being asked in each subparts. They're all related to the main part. So what has been provided, and again, I'm looking at, this is the September 16th letter. The state has provided redacted versions of logs or other documentation mandated by the revised protocol, including but not limited to the chemical preparation sheet, the department's records relating to the execution, and any documentation of the review and changes made by TDOC personnel. They also answered number 8 on that same September 16th letter. All logs or documentation maintained by individuals assigned to specific posts throughout the prison. That is 2 requests. That request had 14 total responses. They answered 2. On September 26th, they provided responses to looks like nearly all of our requests. That's the request that had the outstanding exhibit, or request number 4. That was still being processed. On October 20th, they denied every request except for 2. There were 11 total requests. Requests 1 and 2 had 5 subparts. By my estimation, it looks like about 45 different requests, Your Honor.
Or outstanding.
Total requests, not including the ones that have been responded to. And again, we laid this out in our petition. We were originally asking requests based on timelines built into the protocol. So for example, 30 days out, there are certain things that the department is supposed to do prior to the execution, 14 days out. And so for the execution of Oscar Smith, we were trying to track those deadlines in the protocol. For the execution of Byron Black, we combined all of those requests into a single request to limit the burden on the department. But the information requested is substantially the same.
Okay. All right, anything else?
No, Your Honor.
Okay, other than to just do this with a blanket approach and rule against the state because it has not met its burden of proof, I don't believe there's any responsible way in which I can do this, aside from doing that, without looking at the records. How soon can you get the records here? Do you have them here with you?
I do not have the records here with me, Your Honor. I would have to speak with our client, Department of Corrections, in order to see how long it would take. It shouldn't.
It's been going on since May 1. All right? There's more than enough time here. This ought to already be assembled.
Yes, Your Honor. It shouldn't take us long to get the
haven't
records.
You've already gone through them to deny them, so they ought to already be
Certainly here, certainly, Your Honor, but we can't just, these are incredibly confidential documents. They can't just be faxed, or they would have to be either, like the Davidson County Chancery Court didn't even want them documents in his chambers because they're that confidential, out of fear that they could be leaked. So we would want to consult with Your Honor as to the best possible way to do this. If you would like.
It says in camera review, doesn't it?
Certainly.
That means chambers. That's where they'll be reviewed, but of course they would not be left overnight in chambers, or they wouldn't be left in chambers if I'm not in there. They would be locked up in a vault that no one else can go into.
Certainly, Your Honor. So that, yes, I would.
We have 2 vaults here.
I would, yes, if you're more comfortable than the Davidson County Chancery Court is.
We've got to get going on this. Is running too long.
It's just yes, it's just, I'm just speaking of practicalities. I'm just the only example of this I have is the Davidson County Chancery Court. The Davidson County Chancery Court wanted to come to the Attorney General's office to review the records.
I do not want to go to the Attorney General's office to review the records.
That's fine, Your Honor. We can have the records brought to you.
I want in camera review.
Certainly.
Okay.
Would you be amenable to having a representative from the Department of Corrections to be there as well while the documents are reviewed?
Well, the problem then is that there's nobody there from the other side. I'd have to have both sides there, but you don't want that, correct?
That is correct, Your Honor. I'm not talking about an attorney necessarily, an advocate, but simply a custodian.
That person would have to be prepared to stay overnight, because it may be that things come up in here that I have to go to, like this case. Like you said, you didn't have much time, well, neither did I.
Certainly.
Okay.
Understood, Your Honor.
All right, but that person would have to be prepared.
I'm just trying to get his.
Day and night.
I'm trying.
Not here, locked up in the court.
Certainly, I'm just trying to get as much information as I can, because when I go talk to the client, they're going to have lots of security concerns about how this in-camera review is conducted. So, well, certainly, we're happy to provide the documents. It's simply a matter of what is the way to do this without these documents getting leaked in any way. That's what they're going to have questions about that. So I was trying to get Your Honor's take on those issues. So.
What does the other side say about a representative from the department? They would be with their records anyway, would they not?
Your Honor, I think if it's a records custodian, that would certainly be appropriate. If it was anyone from the Attorney General's office, we would certainly object to that. And we would be happy to file, as a late filed exhibit, the records that we did receive from the request that we made.
What I need from you is a list of the records that have not been produced. There's 45 items, correct?
That was my estimation.
45 requests. All right, and specifically, taking out the ones that have been produced, redacted, whatever, those withdrawn, there only knows one withdrawal.
Yes, Your Honor.
And then there's a couple of withdrawals of denials or basis for denials. And then I need the state to be prepared to be able to coincide its responses with the items you show as unproduced. Would that be difficult for you? For instance, number 1, then you have where I have a file folder or something that says item number 1. I can look at it.
Yes, Your Honor. We can certainly, try to so we can correlate the records to the individual response. There'll be overlap on some of these because I think some of them are quite repetitive, but we can do our best to try to.
If I have that's repetitive, then you put it in a separate file folder that says repetitive with number 4.
Certainly. Okay. Yes, we can do that, Your Honor.
And Your Honor, would you like that filed with the court and serve a copy on the state, or would you rather like a letter form? Okay.
No.
Yep, we can do that.
Filed with the court and a copy to the Attorney General's office.
We can do that this week, Your Honor.
Okay. Do you have a position on how long they should have to get the records to the court?
I think we've detailed the delay in our petition. The first request was sent in May. May 1, yeah. I should have trusted Your Honor's judgment on that. We would, as soon as possible. Well, I think within 2 weeks, I think would be reasonable, Your Honor.
Mr. Dowler, I saw the smiles there. As soon as possible. Okay, how long do you anticipate this review by the court would take? I don't know what I'm gonna be looking at.
It's hard to say, Your Honor. I don't know how long it would take you. It's certainly complex, is all I would say, which is part of partly explains the delay from May 1st, is that this is not straightforward. The department is being as careful as possible with these records, and it's not easy. So I would say it would take some time, Your Honor.
It would take me some time. It would take you some time.
Yes,
It would take me some time in order to review.
review each document and determine whether it's confidential under 107504H, I do believe would take, a day or two to get of only doing that.
Okay, and do you have any time period at all for being able to get them here?
Your Honor, with the holiday, I think 2 weeks is reasonable, possibly sooner. I think 2 weeks at the max. Could possibly get them sooner. We know we have Thanksgiving holidays coming up, but I think 2 weeks is reasonable.
What do you say for that?
2 weeks would be fine with us, Your Honor.
Okay, we'll take a recess and we'll go look at my calendar. Stand in recess.
Yes. It's an unpublished case.
Oh, I would have spelled that way wrong. Let's see. There it is, Lexus. Thank you.
Thanks.
So I know he wants the ruling from the first part. Are you gonna want the whole transcript, do you know?
Yeah, probably.
Regular delivery, or do you know when you'll need it?
Yeah, how much, what's the difference per page?
I don't know, I don't do the billing, my
Yeah,
office handles
We
all.
have that information.
Oh, do you have like the not proofed transcript? Do you know what I'm talking
I
about?
know, a rough draft.
Yeah,
This one would be difficult to do a rough draft on. I could not get that to you overnight. I would rather just type up because I've got another job I'm expediting. I've got a job tomorrow they're gonna order expedite, so I can get it to you next week.
Oh, I think that'd be fine.
Well, wait a minute, what about, is he gonna do a ruling on,
I don't know.
could we expedite the rulings for Friday?
The ruling from the first part?
Yeah.
Yeah.
Oh, I could do that, because that was only 5 to 10, it
Yeah,
wasn't
and
very
if
long.
there's a ruling
On
about.
this part too,
Yeah.
expedite just the rulings and then regular transcript,
Yeah.
the whole thing,
Yeah,
regular
I
delivery,
think that
okay,
makes sense. Yeah.
okay.
Yeah.
Alright. Did you hear that, Luke, they want the rulings by Friday,
Okay.
if there's a ruling on this, and then the whole thing
Okay. Yeah,
is
that makes
within
sense.
2 weeks, regular delivery.
Yeah, I think that makes sense.
Whatever the orders
Sure,
are.
that's
Yeah,
fine.
that makes sense.
And then it just goes to you, right?
Yeah,
Just you.
that's fine.
Are you arguing anything else tonight, or is it?
I don't think so. I think he's just gonna tell us
Okay,
when
because I
when
had
to
to
have
make
the.
sure that I had to be out by 4. I have a doctor's appointment in 45 minutes that I have to get to. I can't miss a meeting. That's why I told him before I accepted him, I have to be out by 4.
And I would have assumed for sure that.
4:25, I can still make it, or they will charge me if I don't miss my appointment.
I can't imagine it'll be much longer.
Okay. The joys of court reporting, you never know.
Yeah, 'cause you
I've
never
got to
know.
be out. Mary said, let me know, and I'll come and cover for you. Well, I can't because my hands are busy, I can't call you. So,
But I'm sure this isn't your first Weaver hearing.
what's that?
This isn't your first Weaver hearing, I'm sure. So.
Yeah. And I didn't mean to interrupt you, but when he's talking over.
Oh, no, you're fine. Yeah, we were.
It's just like, I can't get to you.
Yeah, no,
We could do that list. It's not like a Zoom version. It's not like, I mean, courts are a court.
Right.
somebody get over here, just in case?
I'm sorry?
Can somebody get over here,
No,
just in case?
Mary will take her a half hour to get here.
Oh.
Do they not have anyone on staff at all who does
You
that?
gotta arrange your own court reporters. State court.
Should we do?
Well, she was gonna try to find a colleague.
Okay.
But this thing today, everybody's,
On their way home, yeah.
fortunately, we're only like 10 minutes from here, 10, 15 by the time I get to the car, so.
Yeah, he doesn't, he's not gonna.
Is that-
He's not gonna wanna be here very much longer. either.
I think he's usually done 4 or
Yeah, that's
4:30
what I was
anyway,
curious.
yeah.
Yeah, no, that's good. 'Cause I haven't been.
You can remain seated, Chancery Court's back in session.
Do we have everybody back? We don't, do we?
I think they're outside, Your Honor.
Get them back.
Girly girl, is this yours? Is that back here? Don't wanna take someone's, I'm not sure whose these are, but I'll leave it right there.
Well, no, it's mine, but pictures is on back there.
These programs were not supposed to.
I promise, I didn't do anything, I promise.
That doesn't mean somebody else has.
Okay, well, I'm blaming it on someone else, not me. Oh, okay, well. Okay, there we go. Thank you, Paul. Oh, was closed. Thank you.
How about the afternoon, December 3 at 1:30, that's when the records would arrive? The custodian would need to be prepared to stay, mail the next day.
Your Honor, there's a logistical issue with a couple of the documents. They're currently under lock and key with the department, and only one individual has access to them. They haven't even arrived at our office. So I think that was one of the reasons that Chancellor Perkins wanted to go to an off-site location too.
Okay, well, you can designate for me which ones are.
Okay.
I don't know why they couldn't be brought here by the representative of the department.
We can talk to our client to see if they would be willing to bring their safe here to have it be kept in
All
the
right, this
office.
is your mic check.
And those, I could look at those first, he or she. Okay, so when can you give me the items, list of items not withdrawn, not produced?
We can have that to you tomorrow, Your Honor.
Oh, great, all right, and then over to the Attorney General, right?
Yes, Your Honor.
And then we'll take it from there, December 3, 1/3. And I don't anticipate any of you would be here, but we'll stop in. That'd be fine, be good to see you.
Love spending time with you, Your Honor.
And Your Honor, the custodian would like the opportunity to provide context with those records to inform
you.
your review to the extent that something might not be obvious on its face. Is that permissible?
Deborah,
I think we would object to that, Your Honor.
you
I think we
not-
would object to that, Your
You
Honor.
object to them speaking to the record.
I guess to the extent of what the context would be, I mean, certainly if they're explaining what records are, then we would be okay
If
with
they're
that.
trying to point me to where the pertinent parts are.
Would it be more amenable if they were just there to answer Your Honor's questions rather than
I think
to
it'd be the same.
provide
problem.
unsolicited information? Is there a distinction to be made there?
And that would be the same problem for you, but on the other hand, I doubt if I would be persuaded off my feet,
I have faith in you, Your Honor.
but. You do or you don't object?
I think if Your Honor had questions and had specific questions for the custodian, I trust Your Honor's judgment. I don't think that we would object to that.
Okay, thank you. And are you gonna do the order on this?
Yes, Your Honor.
Okay.
Well, Brittany, people whose federal food assistance payments were paused during the government shutdown may have to reapply for that program. U.S. Agriculture Secretary says the Trump administration is cracking down on fraud by requiring everyone to sign up again for SNAP benefits. While it is not official, we are gauging reaction and explaining how it could impact Tennesseans who rely on the help to put food on their tables. And if you saw some UT athletes around campus this morning, they weren't training, they were picking up.
Hearing, the ruling, and then just a regular transcript.
Yes.
Okay. I've got your information on the
Oh, you
notice.
have it,
Yes, you gave me a copy. Thank you.
Yep.
Thank you all.
Thank you so much. Hopefully you get out of here.
I will. Don't wait on me.
Probably been in tighter spots.
Not really.
Sorry.
Usually those tire spots make me miss it totally. Thank you all.
Thanks.